Okay. Good morning, everyone. Welcome to today's class. I'm your facilitator, for me, Johanna. We'll be taking business law, registration of business and compliance requirements. Registration of business and compliance requirements. That's what we'll be looking at today. And what are the objectives? What are the things we would like you to learn today? The objectives of today's class is to enable participants have a basic understanding of the nature of the legal system in Nigeria, to enable participants understand the legal regime, to understand the legal regime and regulatory agencies regulating businesses in Nigeria, for participants to know the types of business organizations and steps in the formation and registration of businesses in Nigeria, understand the basic nature and elements in a commercial contract. So basically, these are the things I hope by the time I'm done teaching or or talking about, you have a basic idea of all these things by the time we are done with the class. So what are the topics that we'll be looking at? One, we'll be looking at the Nigerian legal system, the relevant government agencies regulating businesses in Nigeria, types of business organizations, and the legal implication of the various types of business organization, registration of business organizations, and law of contract. The Nigerian legal system, relevant government agencies regulating businesses in Nigeria. So by the time we discuss the Nigerian legal system, you get to have an idea of how the Nigerian legal system works. So then we talk about the relevant government agencies regulating businesses in Nigeria. So by the time we are discussing this, you get to know what are the agencies. So I know you know some of the agencies, but by the time you discuss those of the ones we discuss and you are not aware of their function, by the time we are done, you get to know what their functions are. Then we have the types of business organization and legal implication of the various types of business organizations. Then registration of business organization. Then finally, we'll talk about the law of contract. So let's start with the Nigerian legal system. When we talk of the Nigerian legal system, in this sense, we're talking about the totality of laws or legal rules and legal machinery which obtain within Nigeria which is obtained within Nigeria as a sovereignty. We're talking about the legal rules, legal totality of laws, legal rules, and legal machineries which are obtained in Nigeria. When we talk about legal rules, we're talking about the different laws that are obtainable in Nigeria. I don't know whether you know, I believe some of you are aware that we have what we call the laws of the Federation of Nigeria. The laws of the Federation of Nigeria comes in volumes and alphabetically. It contains all the federal laws we have in Nigeria. So when we are talking about the Nigerian legal system, we are talking about the various laws. We are talking about the the karma, the penal code, the criminal code, and the University Act, all laws in Nigeria. That's when we talk of even the ones that are enacted by State House of Assemblies. So that's what we are talking about. The Nigerian legal. So when we talk about the machineries, we are talking about the executive, the legislative, and the judiciary, because the laws do not exist in vacuum. There must be agencies that will be there to enforce them. So basically, these are the this when we talk of Nigerian legal system, we're basically talking about all these things: the laws, the various agencies of government, which is which form parts, because various agencies of government also are part of the executive arm, because they are the ones that implement the policies of the executive arm of government. That is the which comprises of the president and his cabinet members. Then we have the executive. Then we have the judiciary. So let's look at what law is. When we say law, in we are saying for different societies they have law, different communities, different families have law governing the conduct of persons within that society, governing the conduct of persons within that particular locality. So I believe every family has a law, but for the purpose of this class and concept of law, I from what you can see on the slide, I said it means different thing to different people. But to the lawyer and to the law profession, is more interested in the narrow and guided meaning of law as a rule of human conduct, tacitly or formally accepted by people as binding and backed up by some as binding and backed up by some mechanism for the sustenance of its binding nature. It's You can see from this definition that is a rule of human conduct tacitly and formally accepted by people. One, it must be formally accepted by people and has to have a binding and backed up by some mechanism. For a law to be effective, it must be binding by on the people and it must be accepted too. And there must be mechanisms that will be available to ensure its sustenance. For instance, the Constitution of Nigeria, if you check the preamble, there's a preamble that is saying all we, the people of Nigeria, have agreed that we will be guided by the provisions of the Constitution, because the Constitution is the ground norm by which other laws are gotten. So these different arms of government are there to ensure the binding nature of this law. They are there to enforce the law. So the Constitution is the source by which other laws are gotten in Nigeria. That is why we lawyers call the Constitution as the ground norm. So the law is there to regulate human conduct, but it must be formally accepted by people that they agree that this law should govern them. So if it's not accepted by people, then definitely there will be problem, because people will find it hard to obey the law, and it must be backed up by some mechanism. So that's the definition of law for the purpose of this class and for today's uh, lesson that we'll be discussing. So since then, these Nigerian laws that we're talking about did not just fall from the sky. There are sources. When we talk of sources, we are saying, how did we get this laws? Where did we get this laws from? So we have the received English law. When we say the received English law, we are talking about the common law and doctrine of equity. We're talking about common law in the sense that common law and doctrine of equity are laws that were developed back then in England. Common law came as a doctrine of equity came as a result of common law. Then, because back then in England, there was no common law. So all people had the different communities, different localities had their different laws. There are laws governing their their day-to-day activities, just like we have our customary laws. So back then in England, what happened was that then the king would send out itinerant justices that will go to various communities for the purpose of administering justice. So this itinerant justices will go to communities in England back then. So they will administer law based on the custom of the people of that particular locality. So after they've administered uh, justice based on custom of the people, they'll come back to the crown, that is the headquarters, to uh, discuss to discuss those customs they encountered. So they will look at the good ones and they will say, okay, this one is good, this one is good. So by doing that, they brought all the laws together and it evolved to what is known as the common law in England. But however, over time, the common law became more concerned about form and procedure rather than administering justice. What I meant by form and procedure is that rather than being concerned with administering justice, the law is more concerned that if you to follow procedure, because the law is written now. If you don't do that before you approach the court will not hear your case. So even if you have a right to be heard, or you have you were supposed to get judgment or something, but because you failed to do something before approaching the common law court, the court will not hear you. For instance, if the law says, the rules of that court says, before you come to court, you must serve before you come to court, you must you must okay, before you come to court you must pay 17 naira. Then you went ahead and paid 15 naira. So the court at that period, because it says, the law says you must pay 17 naira, but you decided to pay 15 naira, the court will not be willing to give you a second chance to entertain your case. It's just an example I'm using. So it became more concerned about form and procedure. So people became dissatisfied because they were not getting justices, because from the common law courts back then in England. So as a result, they began to petition the crown. So the crown then comprises of the King's Council, and the head of the King's Council is the Chancellor, who was a priest back then in England. So as a result of that, people petitioning the crown, based on the decisions of the common law, where they are not satisfied with the decision of the common law, they will petition the crown, more like an appeal. So as a result, once they appeal to the crown, it's the chancellor that will listen to the matter. So, and the chancellor is a priest. So, as a result, the chancellor will administer justice based on his priestly background. So, he will look at the facts of the case and say, okay, so the doctrine of equity evolved. So that's why I said the common law and doctrine of equity are English received law. So the doctrine of equity evolved, and doctrine of equity in this sense is not fairness, rather is 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 a law developed by the Court of Chancery for the purpose of mitigating the harshness of common law. So that period, that, for instance, that time I used the example of 15 naira and 17 naira, just an example. If you fail to pay 17 naira and you paid 15 naira, courts of common law will not hear you. But the court of doctrine of equity will say, just because of 15 naira, you will not hear his case and the rest. So they will go ahead and hear the case. So as a result, the doctrine of equity evolved. And this common law and doctrine of equity, they still form part of our law as I'm talking to you right now, because there are some of our laws that are based on common law and doctrine of equity. That is why we still have maxims like, he who comes to equity must come with clean hands. He who seeks equity must do equity. Equity looks at the intent rather than the form. So all these maxims are there and are still being used up to now in our laws. Then we have the Nigerian legislation. We have the Nigerian legislation. So when we talk of Nigerian legislation, we are talking of laws that are passed by the National Assembly or the House of Assembly. So it's common knowledge that we have the Senate and the House of Representatives. The Senate and the House of Representatives are responsible for passing the laws in Nigeria. So once there's a law that is presented, a bill that is presented before the House, they will listen to it, then pass second reading committee stage, and then finally it will be passed into the law and assented to by the president. Then it becomes a law. For instance, let me give you an example. The recent Kama. The Kama used to be a bill. It was the former, I think, this is the ninth or eighth National Assembly that passed it into law. Then recently, President Buhari assented the Kama. It became, so the Kama that was existing was repealed, and now we have an amended Kama of 2020. So these are examples of laws that are passed. If you go to various states too, you will see their House of Assembly formulating laws. Then when we talk of customary law is also a source of Nigerian law. Before the coming of the English people, we know that people had their own, the various communities in Nigeria had their own laws, and they also form part of our laws because as the one of the notorious customary law known in Nigeria, that once it goes to the Supreme Court, that is notorious that you don't need to prove anything because it's well known in Nigeria. It's the Benin customary law of inheritance. The fact that the eldest male child will inherit the house in which the father was staying before his death. So these are examples of customary law that are applied in Nigeria because, as we know, it's a body of customs and traditions which regulate the various kinds of relationship of members of the community in their traditional setting. So that's why today we have customary courts too in different in the south administering customs. That's why you see the people headed such courts are people who are familiar with the custom of that locality. Then we have another source of Nigerian law is the judicial precedent and case law. So when we talk about judicial precedent and case law, we are talking about a situation whereby in Nigeria, precedent and case law, we know that yes, the legislature makes the law. Once the legislature, once the legislative arm of government makes the law, or sometimes it is the interpretation of the judiciary that becomes the law, because sometimes they will go to court seeking interpretation of a particular section of law. So once they go to court, whatever the court interprets that section of law, it now becomes law. And there's what we call judicial precedent. Judicial precedent in the sense that if the highest court in Nigeria says, uh, let's say the matter begins at High Court, which is a lower court, it goes to Court of Appeal. Then you know in Nigeria, Supreme Court is the highest court. Subsequently, we'll discuss it. Then I'll still discuss this precedent and case law so that you have a good understanding of what I'm saying. Then I'll also use an example for you to grab what this judicial precedent is and case law. Then we'll talk about international law. We know that there are various treaties, conventions, international customs and practices that regulates relationship between various countries. That is why you see Nigeria is a member of UN. And if you look at chapter 4 of our constitution, you see is the declaration of is about chapter 4 is about human rights, and chapter 4 is basically we adopted the United Nations Declaration on Human Rights and also the African Charter on Human Rights. So these are laws that when they are domesticated, they become part of our laws. So Nigeria will ratify the treaty by domesticating it. Once it is ratified, it is for the National Assembly to domesticate it by passing it into law. So the next thing we will look at is the hierarchy of Nigerian courts. When we say the hierarchy of the Nigerian courts, we're talking about the Supreme Court, which is the highest court of the land. So at this point, you get to know judicial precedent and case law I'm talking about. The, judicial precedent and case law that I talked about earlier. So the Supreme Court is the highest court of the land. Whatever the Supreme Court decides becomes the law. For instance, the issue of the gubernatorial uh, issue that went to Supreme Court. The Supreme Court, after looking at the the, the cases presented to it by various parties in the matter, decided that the candidate of the APC is the governor of Imo State. So when issues of similar nature goes or comes up, lower court of appeal now we look at the circumstances of the case, we look at the facts of the case, then it will decide based on what was decided by the Supreme Court. So if the Supreme Court decides on something, the Court of Appeal cannot go and say, we are changing it. No, the Court of Appeal must follow what the Supreme Court decides because the Supreme Court is the highest court of the land. Then after the Supreme Court, so and whatever the Supreme Court decides become the law and is binding on all other courts in the country. It's binding on the Court of Appeal, it's binding on the Federal High Court, it's binding on the State High Court, it's binding on the National Industrial Courts and all other courts. So we have the Supreme Court, we have the Court of Appeal, then we have the Federal, the Court of Appeal is next to the Supreme Court. So courts from matters from superior courts of jurisdiction like Federal High Court, State High Court, National Industrial Court. If you have matters in any of these court and you are not satisfied with the judgment, you can appeal to the Court of Appeal. So these are courts you appeal to. And the Court of Appeal is a court of appeal. Even the Supreme Court too is a court of appeal, but technically it's the final court of appeal in the land. Then we have the Federal High Court. The Federal High Court, by virtue of Section 251 of the Constitution, the Section 251 of the Constitution listed out matters that can be heard by the Federal High Court. So these are matters that have to do with federal agencies, matters that have to do with interpretation of karma, companies, not contracts, simple contracts. So if you go to Section 251 of the Constitution, paragraph F, you get to see sub-1 paragraph F, you get to see those things that the Federal High Court can entertain. Then the State High Courts and that of the FCT High Court, they have unlimited civil and criminal jurisdiction on almost all issues. They have uh, civil and criminal jurisdiction on all issues. So if you have any matter that does not fall within the jurisdiction of the Federal High Court, is the State High Court, and does not fall within the jurisdiction of the National Industrial Court, then it's the State High Court that has is your lawyer will determine all those ones for you. But for the purpose of this class, it's just for you to have an idea. Okay, this is what this court does. This is what this court does. Then for National Industrial Court, is basically the jurisdiction of that court is to entertain matters relating to labor matters, to trade union matters, master servant relationship, and all other things. That is what this court, the jurisdiction of the court is. That is to entertain such things. Then we have the Sharia courts, we have the customary courts. The Sharia courts where parties are subject to Islamic personal law, so they can submit their matters. When they have cases or issues, they can submit themselves to the jurisdiction of the Sharia courts. Customary courts, as I said earlier, based on the custom and localities of the people. So we have customary courts, and they are there to administer justice based on the custom of the people of that locality. So that customary court in that locality is for the court to administer justice based on the customs of people in that particular locality. Then we have the magistrate court. The magistrate court is a court of inferior records. So it has criminal and civil jurisdiction, but it's limited. It has a limited jurisdiction in terms of the subject matter it will entertain and monetary jurisdiction too. If some matters that if the money exceeds certain amount, magistrate court cannot entertain those matters. It's a court of lower jurisdiction and summary jurisdiction too. So then we have the area court. The area court too is just like the customary court. It's just nomenclature. In the north, they are referred to as area courts, while in the south it's called customary courts, but they are meant to administer customs of the people. Then next we'll look at civil law. So when we say what basically is civil law, when we are talking of civil law, it serves to regulate the conduct of person in their interpersonal dealings with other people. So it's just there to regulate your relationship with other persons. That's why we have civil law. So that's why it confers status, rights, and obligations on individuals or juristic persons. So what we have civil law is basically is to regulate relationship between parties. Let's take for instance the issue of trespass. If so, you are in possession of a property, is your property, and somebody that decides to come and stay in that property, and he knows that it's not his property. So you, as a private citizen, has a right to take him to court for you to enforce your right, which is exclusive possession of that property as the owner. We have other things like passing off. So that is basically why we have civil laws regulate relationship between persons. Then we have the criminal law, which is the criminal law is the body of law that relates to crime. It prescribes conduct perceived as threatening, harmful, or otherwise and endangering to property, health, safety, and moral welfare of other citizens. So normally, for criminal laws are there to regulate relationship of individuals and the state. There are some crimes you commit that is no longer, even though it's against an individual, but because it has been prescribed that it has been written down that once you commit such act against a person, that becomes a criminal it becomes a criminal breach and you'll be punished because already there's a punishment prescribed and the offense is written down. So because of that, whatever you do, it becomes a criminal, it becomes a criminal law. So the main objective of criminal law is to punish wrongdoers, thereby seeking to protect the collective interests of citizens against detrimental conduct of its constituent members. So the entire Nigerian criminal justice, we have the judiciary, the police, the ICPC, all these ones are there to ensure that people conduct themselves properly, not at the detriment of others. So that's why, and normally it's the state that prosecute. If you see where a private individual is prosecuting, where you see a private lawyer prosecuting, then he must have obtained a fiat from the AG of that state or AG of federation. So the next thing we'll look at is the relevant regulatory agencies. So what are the relevant regulatory agencies that regulate businesses in Nigeria? We have the Corporate Affairs Commission. So the Corporate Affairs Commission, we'll talk about that in details. Then we have the Federal Revenue Service, which we'll also talk about that subsequently in detail. Then we have the Central Bank of Nigeria. I know everybody knows of the Central Bank of Nigeria. The Central Bank of Nigeria is the apex financial bank in Nigeria. It is the apex financial bank in Nigeria. It is the financial regulator in Nigeria. It ensures that other financial institutions abide by the rules and guidelines set out for carrying out financial transactions in Nigeria. And the CBN is also responsible for rolling out general policy for the growth of the Nigerian economy. So I think, was it in September that the CBN reduced the lending rate to 11%. All this is to encourage economic growth of Nigeria. And the CBN was established by the CBN Act of 1958. I guess, CBN Act of 1978. Sorry, CBN Act of 1978. But the current framework which the CBN is operating now is the CBN Act of 2007. So that is why the CBN, the governor of the CBN is in charge, and with members of the team, they are responsible for setting out the general guidelines. Then we have the Asset Management Corporation of Nigeria, AMCOM. AMCOM was established in 2010 by the AMCOM Act, though the act was amended in 2019. And the purpose of AMCOM, the purpose of establishing AMCOM is to ensure liquidity flow in Nigeria. When we say to ensure liquidity flow in Nigeria, what we're saying is that for them to ensure that money flows in the financial system in Nigeria, they ensure that there is money. Uh, that's why it is their responsibility to manage and severe toxic assets from the Nigerian financial institution. That is non-performing loans. When we have non-performing loans in banks, it's the responsibility of AMCOM to take over that loan from the bank and pay off the debt so that the bank can have money to lend to other borrowers if they come. For instance, let me give you an example of how AMCOM carries out its function. For instance, there's a company that approaches GT and borrows loan from GT, let's say a loan of 10 million, and the company mortgage its property, or yes, it mortgages property, but the company was let's say, okay, the company, definitely a bank will not give you a loan without you giving them a collateral. The bank it mortgage its property, but the property is not does not cover for that 10 million, and in the end, the bank goes to before the bank goes to court, or before the bank decides to sue the company to court, and the loan has not been performing, the bank has not been financing the loan, has not been repaying the loan to the bank. So what AMCOM will do in this case, it will ask the bank for its balance sheets, which loans are not performing well. So those loans that are not performing well, what AMCOM will do is AMCOM will come and buy those loans. AMCOM will come and buy those loans from that bank. So those people that borrowed from AMCOM are no longer indebted to AMCOM, are no longer indebted to the banks. Rather, they will be now indebted to AMCOM. So that company that borrowed 10 million from GT Bank will no longer be indebted to GT Bank. Rather, it's now indebted to AMCOM. Then AMCOM will go after that company for the loan. Then we have the standard, the National Agency for Food and Drug Administration Control. We'll talk about that too in detail. Then we have the Standard Organization of Nigeria. We'll also talk about that in detail later. Then we have the Federal Capital Territory, the Federal Development Authority, or the State Commissioner for Lands. When you want to do business that have to do with that have to do with land, then sorry, please. When you have business that have to do with land, the appropriate body or agency you approach is the land agency within that state you want to carry out that business. If you are in the FCT, is the FCDA. So these are some of the things. But some like Corporate Affairs Commission, federal, we'll still discuss them. That's what we subsequent. Now, the next thing we'll discuss is the Corporate Affairs Commission. We are going to look at what are the functions of the Corporate Affairs Commission in details. So from the slides, you can see that the Corporate Affairs Commission was established by the Companies and Allied Matters Act, CAMA, 1990. And it is the regulatory agency in charge of registration, regulation of business and non-business organizations such as companies, business name, and incorporated trustees. So these are the responsibilities of Corporate Affairs Commission, and it's there to ensure registration after you've before after you register there's what we call pre-incorporation. At the pre-incorporation stage, before you register your company, CAC plays a vital role. After you've registered your company, CAC still plays a vital role in the management of your company. So section 7 sub 1 of CAMA sets out the function of CAC to include regulation, supervision of the formation, incorporation, management and winding up of companies, maintain a company's registry in all states of the federation. So CAC is responsible for regulating, it supervises the formation because it's CAC that will see to the formation of company and it eventually incorporates the company, the management. If the company is no longer a going concern, if the company is no longer functioning, is no longer performing, is the it's easy. You approach if your company is no longer a going concern, that is, you don't want to run the company again, you approach CAC to wind it up. And it's also the responsibility of CAC to maintain a company's registry in all states of the federation. So once you register a company, CAC has a file for you. So you get it. So it also includes the power to carry out investigation into the affairs of the company if the situation demands. So CAC has the power to carry out, because if you are registering a company, for instance, you give CAC the objects of that company. Like of recent, I just read in the news that CAC has deregistered a non-governmental organization. Enough is enough. The basis CAC gave is that the object is different from what they are doing, but the company has since come out to say no, they are registered as a limited guarantee company. So what CAC does is it has the power to carry out investigation, because at the time of incorporation you give them your what the object of the company will be. That is what the company will do. So it's when you begin to deviate from such objects, CAC has the power to investigate and to take over the company. It's not just company. So that's why of recent we had different people talking about the Karma 2020 giving CAC the power to take over churches. So when and CAC will not just take over an organization, an NGO, a company, or any business just like that. It has to go to court and obtain order of court. When it does obtain that order, then that is when they'll proceed to take over that particular company. Then we have the Federal Inland Revenue Service. The Federal Inland Revenue Service is in charge of was used to be an arm of the Federal Board of Inland Revenue, but subsequently by the Establishment Act of 2013, the the Federal Inland Revenue was made an autonomous body, an independent body. You get it? So it becomes an independent body and is no longer an organ of the Federal Board Inland Revenue. Though the Federal Board of Inland Revenue still rolls out general policy for the Federal Inland Revenue Service, and the Federal Inland Revenue Service is in charge of the collection and administration of federal and corporate taxes. So all federal and corporate taxes are the responsibility of the Federal Inland Revenue. And what are the what are these federal and corporate taxes we're talking about? Talking about the VAT, which is the uh, we're talking about VAT. We're talking about company income tax. We're talking about the personal income tax. So all these are taxes that are administered by the Federal Inland Revenue. Aside administering and collection of corporate collection and administration of federal and corporate taxes, it's also the responsibility of the Federal Inland Revenue to administer and control the various tax enactments, which I just mentioned, the VAT, the income tax, the stamp duty, and the rest. All these are responsibilities of of FIRS to control and administer. It also ensures the enforcement of that laws. So it takes us back to when we talk about the Nigerian legal regime. I said some of these agencies are there to enforce the law. So it's the responsibility of FIRS to enforce those tax laws that are specified under Schedule 1 of the Act establishing the FIRS. All those laws that are stated there is the responsibility of FIRS to take care of such. So, so for the purpose of this class, we'll be looking at we'll look at VAT, because we know that VAT is the commonest tax that is applicable, whether you like it. We can evade paying company personal income tax, we can evade paying stamp duty if not you are dealing with some federal government agency, like for instance if you want, but you cannot avoid paying VAT. You cannot avoid paying VAT, because every day VAT is being charged on everything you buy. So as a result, you cannot, even the recharge card we use, you cannot avoid collecting, you cannot avoid paying tax, because by merely calling, sorry please, by merely by merely calling another person on the phone, you will see your network will send you a message that VAT has been VAT so naira. So VAT is simply value added tax. So is a consumption tax that is levied repeatedly on a product or service offered. So when you see value added tax, when you see VAT, that's why you see every time you buy a particular product, it is being you see VAT inclusive, because VAT is a consumption tax. So by the time you start, you are providing, or now that you are providing any service, or you intend to provide any service, is your obligation as a citizen of Nigeria to pay your VAT, which is your value added tax, and you do that by obtaining and completing a VAT form at your local VAT office, which is any FIRS office close to you, where you register, you get your VAT number, so that you remit your VAT to, you collect the VAT on behalf of FIRS and you remit to them the VAT. So these are the things we're looking at. So not everything, as we know, is vatable, because if you check the recently passed Finance Act, you will see there are some things that are exempted from VAT. But that, for instance, businesses that are into cultivation of unprocessed agriculture are exempted from that and enjoy pioneer status, so they are largely exempted from federal taxes. So these are the functions of the functions of Federal Inland Revenue Service that you need to know for the purpose of this class. Then next we have the Standard Organization of Nigeria. The Standard Organization of Nigeria is the sole statutory body that is vested with the responsibility of standardizing and regulating the quality of products in Nigeria. So that is why it's common when you go to the market, you see some products carrying the sign Standard Organization of Nigeria. So it's showing with the tick good, Standard Organization of Nigeria. So the soldier is vested with the responsibility. So that's their responsibility to ensure that goods or products that are within their inventory, you get it, because they have list of products that they are meant to standardize. It's not every product that will be certified by the Standard Organization of Nigeria. So it's the responsibility of Standard Organization of Nigeria to ensure all products that are sold in the market that is within its that is within the categories of product that should be administered by Standard Organization of Nigeria is certified by them. If not, if your product is not certified, then you stand the risk of losing that product to Standard Organization of Nigeria, especially when they go to inspect market. It could be through seizure, confiscation, destruction of any substandard product. Because if a product is meant to be certified by the Standard Organization of Nigeria and it is not, there's this presumption that that product is of substandard. So what are some of the functions? We have them here is to investigate uh, the quality of facility, materials, and products in Nigeria, and establish a quality assurance system to ensure reference standards for calibration and verification of measures, to compile an inventory of products requiring standardization, to foster interest. So these are some of the inventory of products. As I said, to compile an inventory of products requiring standardization, not all products, because those products that fall under the purview of NAFDAC, you cannot take it to Standard Organization of Nigeria to certify. So based on this, they have their inventory. So for the purpose of this class, if we said we are going to look at how Standard Organization if we are going to look at the inventory of products that are to be certified by Standard, then we will not leave this class anytime soon. So basically, we just talk about the registration procedure with Standard Organization of Nigeria. And the registration procedure with Standard of Organization of Nigeria is in two ways. It's either e-product registration or the mandatory confinement assessment. So the e-product registration, you just log on to their site. Once you log on to their site, you just you log on to their site. There is a form you fill. Once you fill the form, when you go to their site, you fill the form. That's the e-registration. After filling the form, there are a list of documents. For instance, your CAC certificate, picture of the product, power of attorney, and other documents that they will require is specified there. Then it's left for you to upload that. Then you make payment. Then you register that particular product. Then you have the mandatory conformity assessment program. The mandatory conformity assessment program is for the locally manufactured product. You get this one is to ensure that locally manufactured product meet the standard, the Nigerian industrial standards. So these are things that are put in place by the Standard Organization of Nigeria to make registration easier. So there are also procedures so for that. So I'm going to refer you to a site on the internet where you get to to see the procedure. The site is 618biz.com. 618biz.com. Just or you can Google registration with Standard Organization of Nigeria, because this is not something we could discuss in detail because of time. So you could Google Standard Organization of Nigeria. Under it, you will see the site of 618biz.com will come up, and you get to see the procedure. And aside these two I mentioned, there's also the export guide to Nigeria. The export guide to Nigeria. So before goods are shipped into Nigeria too, it is the Standard Organization has a responsibility to ensure that these goods are of standard. So there's this program that the Standard Organization of Nigeria came up with, which is the Standard Organization of Nigerian Conformity Assessment Program for goods shipped into Nigeria. If you in that one, you will see the inventory of products that if you are shipping to Nigeria, you get to certified with the Standard Organization of Nigeria. I'm going to also refer you to a site where you get in details the inventory, everything. You can go to www.cotina.com. The Cotina is spelled COTENA.com. So if you go to that site, you get to see what are the export guide for the export guide to Nigeria based on the Standard Organization of Nigeria Conformity Program. Then we have registration with NAFDAC. As I said earlier, not every Standard Organization of Nigeria has an inventory of products it registers. Then the NAFDAC too has an inventory of products it's that is for NAFDAC to register. So when we are talking of registration with NAFDAC, we NAFDAC has demanded for controlling, maintaining, the distribution, advertising, exportation, importation, manufacture, and the registration of the categories of products such as goods, drugs, medical devices, and cosmetics, etc. is the responsibility of NAFDAC. NAFDAC has the mandate for controlling, maintaining the distribution, advertising, exportation of these things. So if you are dealing in distribution, NAFDAC is of categories of products which are within the categories of products which are within the categories of products for NAFDAC to administer. Then NAFDAC is responsible for advertising, exportation, importation, manufacture, and registration of these products. We will look at these products subsequently. That is the responsibility of NAFDAC to administer. All businesses dealing in food and related products are subject to regulation by NAFDAC, as it is unlawful to market any drugs or consumable goods in Nigeria to the public without registration with NAFDAC. So NAFDAC, if you are not registered with NAFDAC, it is unlawful for you to market any product that is meant to be registered with NAFDAC. So what are these categories of products that NAFDAC administers? We can see food and water, drugs and medical devices, herbals and cosmetics, vaccines and biologics, chemicals, veterinary products, and narcotics. All these are administered by NAFDAC. We see food and water, drugs and medical devices, herbal and cosmetics. So vaccines and biologics, chemicals. So when you are dealing with all these products, these are products that fall within the inventory of NAFDAC to administer. So you ought to register with NAFDAC so that it will be lawful for you to market such products in the market. Though if whether you are registering food and drugs, uh, food and water, drugs and medical devices, the the specific documentation vary for different of the products. But for the purpose of this class, we'll just look at we'll use the drugs, and the drugs too will just the requirement for registering drugs, and we'll just look at the key requirements, because we cannot pick we cannot discuss in detail all the requirements. We can just pick the key requirements and discuss. And if you are applying for registration with NAFDAC, the application is in two process stage, especially for any product. Application for approval to bring in samples of that product, or application for full registration of product. For instance, if you want to bring in a drug, you want to import a drug from India, let's say Pfizer is a manufacturer of the drug. So you have to apply to NAFDAC to bring samples for them to examine. Then after that, there are other things you need to meet before you begin to begin full registration. So now let's look at for this is just for general requirement and the rest on how to register with NAFDAC. You can go to their office too and make further inquiries. But let's look at the key requirements. What are the key requirements once you want to register drugs? What are the key requirements? So drugs, uh, application is on a single product basis. That means if you have two drugs you want to register with NAFDAC, you apply separately for each of the drug. You cannot just lump the application in one and say I want one NAFDAC registration number for the two drugs. It has to be application is on a single product basis, different for this, different for that. Then you have a written application stating the name of the manufacturer and, and the name of the product. The name of the manufacturer could be a brand, and the name of the product, then completed NAFDAC application form. If it is a company you have that you want to go into the manufacture of the product, then you also with your application you also join the certificate of incorporation with Corporate Affairs Commission. You also have 5 copies of the product dossier. That means when we talk of a product dossier, we're talking of collection of the various documents and data, including data, regulatory documentation concerning research, development, and efficacy of the licensed product. So all this you submit to NAFDAC. That is, we're talking about drugs in this for the purpose of this class. We're just looking at drugs and we're looking at the key requirements. Then 3 packs of the product samples. Then notarized original copy of the duly executed power of attorney from the product manufacturer. When we say notarized original copy of the duly executed power of attorney from the product manufacturer, is what we are looking at is when we say notarized documents, there are documents that need to be authenticated. So especially power of attorney. Let's say you are importing, for instance, you want to import a drug manufactured by Pfizer and from India. So what this requirement is saying that the document, let's say Visa gives you the authority, because power of attorney is just an authority for you to carry out something on behalf of that person that gives you that power. So let's say Pfizer gives you a power of attorney. The power of attorney is for you to notarize the power of attorney. So you have to notarize the power of attorney for it to be accepted by NAFDAC. So, and how do you go about notarizing power of attorney? There are what we call notary publics. In Nigeria, we have them. They are mostly lawyers. So you go, you approach them, they will stamp. But for the purpose of this power of attorney, which is issued to you in India, for the purpose of importing drugs to Nigeria, manufactured by Pfizer, the NAFDAC is saying you can go to either the Nigerian High Commission in India, or you can go to any other ECOWAS, uh, any ECOWAS ECOWAS country mission, or the British High Commission, in the absence of a Nigerian High Commission in that country. But India being a Commonwealth country, Nigeria being a Commonwealth, we have a Nigerian High Commission in India. So if, for instance, you are importing the product or the drugs from India, you could just walk into the Nigerian Commission and execute and notarize your power of attorney. The same applies to the certificate of manufacture too. It has to be notarized by either the Nigerian mission in that country, if you, as I say, if you are importing, and in the absence of a Nigerian mission, the British this thing will also suffice. So the contract manufacturing agreement too. Sometimes in the absence of a power of attorney, we can have what we call a contract manufacturing agreement. That one too can serve instead of the power of attorney, where you are saying, especially when you are going into manufacturing in Nigeria and it is Pfizer, there's what we call franchise. Maybe you've gotten franchise from Pfizer to manufacture a particular drug in Nigeria. So what we're saying here is that what NAFDAC is requiring from you is the contract manufacturing agreement, so that it will be properly executed and notarized. I, there are other requirements too that are required by NAFDAC. Remember, I said NAFDAC is not just responsible for, NAFDAC is responsible also for the distribution, control of the distribution of drugs. So if you want to open a pharmacy too, there are some requirements you need to meet up with NAFDAC, which like the certificate of pharmaceutical products duly issued, current pretended pharmacist license to practice issued by the Pharmaceutical Council of Nigeria, premises registration license from Pharmacist Council of Nigeria. If you want to go into distribution, what I did here is I just match everything, just bringing out the key requirements. For details, and if you need further explanation, you could go to the NAFDAC office nearest to you. They will give you a breakdown, because we cannot discuss all these things in details in this class within just 2 hours. So other things that can be required by NAFDAC is the certificate of registration of brand name with trademark registry. So when we say registration of brand name, that means if the logo and the rest of the company, the trade name, trademark, it has to be registered with the trademark department of the Ministry of Commerce in Nigeria. Then sometimes, especially when you are importing, you have to give them that letter of invitation to go and inspect the factory abroad. So in the end, you pay applicable fee. This one is a form you need to fill. But recently, NAFDAC introduced an online registration procedure whereby you can register your product online. So how do you register your product online with NAFDAC? You simply go to, okay, NAFDAC calls the e-registration procedure as NAFDAC Automated Product Administration and Monitoring System. NAFDAC Automated Product Administration and Monitoring System. So you simply go to www.napams.com, napams.org. So you sign up as a new you sign up or you register a new account as a new client. After signing in, you log in with your registered account, you complete the application form, you make payment. It's not as easy as I'm saying it. When you log into the site, you see the procedure. Though it's something they started of recent, and I can't tell how efficient it is, and we cannot tell how many people have used it so far, and what's the review so far from people. But the the e-registration system exists, I guess, line in line with the manual registration, which is obtaining a form from their office and doing it and submitting it at their office. So that is it on regulatory agencies. So what we are going to look at now is types of business organization, types of business organization and the legal implication of the various types of business organization. So by the time we are done discussing this, you know what are the types of the various business organization, then what uh, what is a business organization? Basically, when we look at what a sorry, we first of all look at what a business organization is, which on the slide you can see. Then we'll talk about the various types of business organization. After we've spoken about the various types of business organization, what are their legal implications? So if you are running a business right now, you will know what kind of business organization you are running by the time we are done with this subtopic, or you will know, and you also know the legal implication for running such kind of business organization. So when we say business organization, what do we mean? We simply mean a legitimate venture to make profit. It's a legitimate venture to make profit. When we say, so if you are into any business uh, that is illegitimate, and you are running an organization carrying out that business, you can't say you are running a business organization, because the the definition said it must be a legitimate venture. It must be a legitimate venture to make profit. So what are the types of this business organization? One, we have sole proprietorship. Two, we have partnership. Three, we have company. So let's look at this business organization in detail now. So by the time we are done discussing this, you know which you are running. The sole proprietorship, as the name implies, is the sole owner of the business. So he runs the business alone. He takes his decision alone. He 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 spends the profit. If he likes, he will spend the profits. If he likes, the way he wants. He's not answerable to anybody. If he dies, the business dies with him. For instance, let's say there is one Mr. Johnson, and Mr. Johnson runs a Johnson business venture. He's the only person in charge. Members of his family are not even part of the business. So once you are running that kind of business where you are the only one, then you are running a sole proprietorship whereby you are the only one running that business, none of your business with anybody. You take the decision alone. You don't need to. The highest that you need to do maybe is to seek advice from others, and the advice is not even compulsory for you to take. You just, if you like, you take. If you like, you don't take it. So, but what if you decide to run that kind of business? What is the implication? The legal implication of running is being a sole owner of a business is that if you borrow money or loan, debt, rent, anything, you are going to repay that alone. As the sole owner, you are personally liable for the debt and liabilities of the business. You are personally liable for the debt and liabilities of the business. So when you borrow money and you are unable to pay and they are coming after you, they can come for your house, come for your car, come for your clothes, anything they can get hold of to satisfy the debt. So in this case, if Mr. Johnson is running his Johnson business venture, decides that okay, this decides to borrow money from a bank. If he decides to borrow money from a bank, that money he borrows and he's unable to pay, he will be personally liable. When the bank wants to collect their money, they will come after him personally. They will go to his house, anything they can get hold of to satisfy that debt, they will carry it and go. So that's the implication of running a legal implication of running a sole proprietorship. Even if the business is registered with CAC, because even if you register does not mean that particular sole proprietorship has acquired legal personality. No, you are still the owner's personal asset and business are inseparable. Even if Mr. Johnson decides to register Johnson Business Venture with the Corporate Affairs Commission, it will not stop the bank from coming after him personally. Then we have partnership. So when partnership, as the name implies, too, is when two or more people come together and decide to run a legitimate business venture. That means Mr. Johnson and Mr. John decide to come together and say we want to run a legitimate business venture as partnership, as partners. Sorry, but there is something about partners. Partners can be limited. Partners can be general. So, except in the case of partners who are limited, general partners have unlimited liabilities similar to a sole proprietorship. So, when we are talking of general partners, let's say Mr. Johnson and Mr. John decide to run a partnership now. If they decide to run a partnership and Mr. John and Mr. Johnson decide that they are going to be general partners. When I say general partners, I'm saying they will be involved in the day-to-day running of the business. That is, none of the partners going to say, I just want to invest and just sit back and watch you run the business. Anything you make, the profit, you just give me my share. Me, I just want to invest. I just want to invest in the business. But as general partners, you are involved in the running of the business. You guys take decision together, everything. So in that case, the your liabilities as partners is unlimited, just like sole proprietorship. When you are indebted to any organization or to any bank, they can seize either of the general partners personal belongings to offset debts and liabilities and other things, because it's a business made up of two or more partners, each sharing the business debts, liabilities, and assets. But in the case of limited partnership, that means Mr. John and Mr. John, in this case, decide they want to run a limited partnership in the sense that Mr. John only wants to invest. Mr. John only wants to invest. He doesn't want to partake in the day-to-day running of the business. In that case, Mr. John is a limited partner. So in that case, when Mr. Johnson decides to borrow on behalf of the business and they are unable to pay, the bank in this case cannot come after the personal belongings of Mr. John. Because Mr. John, by the agreement of the partnership, is a limited partner, and by being a limited partner means that his liabilities is only limited to his investment. Limited to his investment. His liabilities are only limited to his investment. That is, what he invests is what he will be responsible for. So these are the difference between uh, a limited partner and general partner. So, and at what point would you decide you want to be a general partner, and at what point would you decide you want to be a limited? By the time you decide to enter into partnership, at the point of drafting the agreement of the partnership, that is when you decide, okay, I want to be a limited partner, I don't want to be a general partner, or you decide I want to be a general partner. And there is something to note about partnership. If you say you're going into partnership, you must always agree that profit must be shared equally between parties. So you must agree that you will share the profit equally. So then we look at companies. So let's say when we are talking about company, we're talking we also talk about companies and its legal implication. So when we say company, that means you have decided that you are going to register with the CAC and you want to register a company. A company too is another legitimate business organization, a business venture. But we have different types of companies. We have the private limited company, we have the public limited company, we have the unlimited company, we have the company limited by guarantee. But for the purpose of this class, we are going to limit ourselves to private limited company and public limited company. But most considering that most participants in this class would love to go into private limited company. And when we say private limited company, it is just a small company whereby few people decide to few people decide to run a business, legitimate business, to make profit through a company. So in the case when you have a business, be it sole proprietorship that has not been registered, be it a partnership that has not been registered as a company, then you decide, I want to register this thing to be a company with the corporate affairs. From the date of issue, that means from the day you complete your registration and the Corporate Affairs Commission issues you with a certificate of incorporation, your company becomes a person in law. In the eyes of the law, that company becomes a person. That company has acquired a legal personality. That company is separate from you, despite the fact that you are the one that paid for the registration. It is you are the one that gave the company the name. You're the one that, let me use the word, bait the company. Once certificate of incorporation is issued by the Corporate Affairs Commission, the company becomes a separate person and you too become a separate person. So your liabilities in this case, normally if you're registering a company, you have directors and shareholders. So you either be a director or you be a shareholder in the company. And as such, your liabilities are separate from that of the company because the company is an artificial person. So the shareholders of the company have limited liabilities. Let me use, for instance, let me use uh, Johnson Business Ventures I used earlier. Mr. Johnson was running Johnson Business Ventures and it wasn't registered. Then he decided that, okay, I want to register Johnson and Johnson Limited this time. So by him deciding to register Johnson and Johnson Limited is separate from Mr. Johnson, despite the fact that it's Mr. Johnson that will pay that that even though the company is named Mr. Johnson and Johnson Limited, he is separate. The highest he can be is to be a shareholder or a director or shareholder and director in the company. And his liabilities is only limited to his investment in the company. So if the company is indebted to the bank, the legal implication, we look at the legal implications subsequently. So they cannot come after the personal assets of the shareholders and seize it to offset their debts. Rather, it's the company that they will come after. So the company being a human of its own, the company being an artificial person can do the following. The company can buy and own properties, the company can enter into contracts, the company can enter into contract. That's why you will see some certificate of occupancy carrying names of company, because in the eyes of the law, the company is an artificial person. So as a result, the company can own properties. So if the company, let's say Mr. Johnson borrows money from GT and Johnson and Johnson Limited borrows money from GT Bank, and it was Mr. Johnson that applied for the loan as a director of, because there will be meeting of directors where resolution will be reached that they should borrow money from GT on behalf of Johnson and Johnson Limited. So uh, in that case, it is Johnson and Johnson Limited that is borrowing money from GT Bank. So GT Bank now can only come after Johnson the assets. Anything that is named after that is acquired by Johnson and Johnson Limited, that is what the company will and the bank will come after to offset its debt. So let's say Johnson and Johnson Limited has a property. So what the bank will do now is they will go to court, file their case. When they obtain judgment, they will come and attach the property or sell the property to get their loan. Or already, if there is the mortgage, will they will foreclose the mortgage, sell the property, and so it can buy and own properties. It can enter into contract. It's common for you to see uh, companies or entering into contracts, and they can sue and be sued too. You will see, if you go to court, you will see this company versus this company. All these are there. Then the company enjoys perpetual succession. That means it lives forever. For instance, let me give you an example of First Bank. First Bank, if you check their logo, you see it says since 1959. Are you telling me that the people that established First Bank are still alive, or the initial shareholders are still alive? Rather, it's shareholders come and go, directors come and go, but First Bank is still alive. So once Johnson and Johnson Limited will be alive if it is registered, as long as it's a business going concern and it's not wound up in future, then the shareholders will come and go, people will come and go, and this thing. So it can also apply for loan in this registered name. So the moment you decide to register a company, these are some of the benefits you enjoy. One, they cannot come after you personally. It is what the company owns, the people will come after, the people you are indebted to. So let's look at registration of business and non-business organization. Oh, sorry, something happened. I want to share. Okay, I've seen it. Okay, sorry. So let's look at registration of business and non-business organizations. Why register your business? Why register your business? Registration of business organization is done at the Corporate Affairs Commission. Whether any business, whether small or large, will in the long run benefit from corporate and physical product registration. So when you register your product, you benefit from corporate and physical product registration. That's one. If you want to register with NAFDAC, if you are claiming you're running a business, because there are some registration before NAFDAC will do that registration, you must bring certificate of incorporation of your company, or you must of that business and the rest you are doing. Or sometimes they will even require trademark registration. So if you've not done any, you find it difficult. And when you don't obtain NAFDAC registration number, it will be difficult for your product to sell in the market. It will be difficult for your product to sell in the market. So you also have uh, 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 borrowing from bank, and to carry out official transaction, it will be difficult for you to borrow from bank if your business is not registered. So these are some of the reasons we need to register our our businesses. Like for instance, now the survival fund that is to be disbursed by the federal government. If your business is not registered, how can you benefit from such? Because I believe the requirements are you must have a registered business and you must be paying tax. As I don't know whether you are aware that the federal government is registering uh, 200 and something 50,000 business names for people in different states, and there are aggregators that can do that, and there's a procedure you go about, just business names. The purpose of doing that is the government wants to increase its revenue and to capture more people within the tax net. And also, when your business is registered, it's easy for you to pay tax. It's easy for you to pay your tax. So these are the reasons why you should register your your business. So we are going to also look at business startup procedure. So if you not started your business, but you intend to start a business, and if you are running one and you need to make some changes with regards to that business you are running, you need to find a suitable business name to support your business identity. Find a suitable business name to support your business idea. That means the name must be suitable for your business. easily identifiable with the kind of service or product you are offering for sale. So you identify a suitable business location. Definitely, you will not go to an area where that product you intend to sell is that product you intend to sell is being sold in abundance, or that service you want to offer is being offered by so many people. Definitely, you look at the location where you meet the demands of people, because business people are problem solvers. They just solve the problems of others and in the end make money. Register the business name with CAC. Make sure you choose a name that is easy to pronounce, remember, and has a relationship with your type of business. As I said earlier, register with the Federal Inland Revenue Service as a value added tax collection point, so that you can remit your VAT, your value added. As I said, VAT is a consumption tax that is levied repeatedly on a product or service you offer. So if you are selling your product, you need to charge VAT and remit on behalf of the federal government. Register your product with NAFDAC national. If you are producing food and drugs or other related drugs, register it with if standard organization. When that product you are manufacturing or you want to import into Nigeria falls within the inventory of products that are to be certified by Standard Organization of Nigeria. So let's look at that's it about small business startup. So we'll look at the procedure and documents to be submitted to CAC for registration of business name. You've decided the name of the business, you've decided where to run your business. When you've decided everything, the next thing to do is registration with the CAC. So there is something you need to know about registration with CAC. Something you need to know about registration with CAC. If you want to if you want to register with CAC, there are agents available that can register for you. And who are these agents? These are people that are accredited by CAC. And who are the people accredited by CAC? They are either lawyers, one, two, chartered accountants and chartered secretaries. These are the categories of person that can be accredited by CAC to carry out registration of companies. And you, as the proprietor or director of a company or a shareholder, you can register on CAC's portal, on CAC's website, to obtain a portal for the purpose of that registration. But where you find it difficult and you cannot do it yourself, then you can contact an agent to help you do that registration. So let's say you've gotten a name and you've gotten a portal from with the CAC after your registration, or you've given it out to an agent to help you register, and which you know he will charge for his professional fees. Then the agent will submit the name for reservation with CAC, which is for approval with CAC. CAC will go through the name, and there are some things that CAC will look at before approving a name. Is the name in use? Is the name similar? Is the name carrying a word that you will need consent before you can use that name? Is it carrying a chamber of commerce? What like chamber? Such things will not be registered. So when you submit your name and the name is not is in line with CAC guidelines or guidelines for approving of name, what CAC will do, CAC will approve the name for you for 60 days. They will send the message to you that the name you submitted with them has been approved for 60 days. What that means that is you need to fill the form and make payments before the expiration of 60 days. Because at the expiration of 60 days, you will lose the name and the name will not be reserved for you. Get it? The name will not be reserved for you. So in the end, you will lose everything. But once the name is approved and they said you register within 60 days, and you make your payment, then subsequently you can continue your registration. So if your business name, you enter all the details you need, like nature of the business information. You need your means of identification, which could be a national identity card, driver's license, voter's card, or international passport. These are relevant documents you need to register with CAC. So you impute them. You the form will give you, just like any other form, it will tell you what you need to put: name, address, identification number, and the rest. After you filled everything, you after you filled everything, you make payment, then you download the form. After downloading the form, you sign, put in your two passport photograph, then you upload the forms back to CAC. After they've gone through your application online, they will see whether there's something they could query, whether you've not done something correctly. Or you've not done something correctly, what they will do is that they will issue you a query for you to rectify. But to rectify the query, once it's rectified, they will look at it, then they will approve your registration, then they will congratulate you and give you an RC number for the business you register, or a BM. That's what they call it for business name, BM. Then you go to the nearest courier service, they will tell you where you go and pick up your certificate. Then for companies too, is the same thing. After you've gotten the name of the company, but after you've gotten the business idea, but in this case for companies, you will decide which company you want to register. Is it private limited company or unlimited company? Because if you want to register a private limited company, you must have at least 2 to 50 shareholders. But based on the recent past karma, you need at least, with one director, you can register a company, a private limited company. With one shareholder, you can register a company. You don't need at least two anymore. But the fact remains that CAC are still are yet to implement that provision. CAC are yet to implement the provisions in the new karma. So that is why we are still applying the old provision, which says at least two directors. So if you decide that, okay, if it's a private limited company, you must have at least 2 to 50 shareholders. That's the maximum shareholders you can have. Then you have your two two at least two directors too. You need to have at least two directors before you can commence your registration, because the portal will not even allow you to continue with your registration or to move to the next page if you fail if you fail to impute at least two directors. Then there is another thing you need to know, which is the share capital of the company, which is very important. The share capital of the company for small companies like private limited companies, share capital is 1 million naira. 1 million share capital, sorry. 1 million share capital divided into 1 million. You can, how you decide to divide it, it could be 1 million shares, 1 million ordinary shares of 1 naira each. Could be, you could decide to share it anyhow you decide to share it. And when we say 1 million, we're not saying you pay CAC 1 million. No, 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 no. You will not pay CAC 1 million. What is just an artificial valuation of your company. It's just saying that your company is worth 1 million ordinary shares. So if you want to dish out the shares, let's say you have four shareholders, each person will have 200,000 ordinary shares, 250 odd thousand ordinary shares of 1 naira each. So these shares can be transferred to. So let's say you've decided you want to register a public company too. You, the same way, at least two shareholders, two directors for now. But the public companies are usually quoted as stock exchange, because these are big companies and highly regulated. So, but for the purpose of this class and for participants in this class, I don't think any of you is interested in, for now, in registering a public limited company. What is more suitable for you now is a private limited company, just for small and medium. Eventually, if your business grows, you can upgrade it to a public limited company. So let's say you've gotten the name, you submit the name to CAC, and it's not against the rules for names, which is the name must not be in use, it must not be similar with another name, and the rest, uh, other uh, provisions for names. Then CAC will you submit the name. If CAC approves the name, it will reserve it for 60 days. So you are expected to complete your form within these 60 days and make payment. Because at the expiration of that 60 days, everything will disappear, even the name. So that name you reserved, somebody can use it. That's the implication. If you fail to register within 60 days, that form will give you this thing you will need to enter, uh, informations you will need to enter, like you will need to enter the names of the directors, their addresses. First of all, you start with the share capital of the company, 1 million share capital, how you divide the share capital. You go to directors, you go to shareholders, you go to object of the company. What are the object of the company? Each director, you fill in his details and the rest. Then what are the objects of the company? Does the company intend to do? What do you intend to do with the company? So this is what we say. If you say objects of the company and it's contained on the memorandum of the company, you will see it when you are filling the form. Then you will see articles of association also, which you could just simply adopt on CAC website. All these are there. After you've done filling the form, then you can download the form, sign, then upload the form. You wait on CAC. If there is no query, your company will be approved and RC issued to you. So that is registration of companies with CAC. So these are just, it's just a guideline of the fees. These are not the fees, because fees are just policy that they are subject to policy, which can be changed at any time. So these are just for the purpose of this class. We just decided to use the fees, but the registration is not that expensive. The registration fee, you put in you put into consideration the registration fee, you pay to CAC, stamp duty, because there is need to pay stamp duty, and the share capital of the company will determine what you pay to CAC. Is the share capital of your company will determine what you pay to CAC. And there are some companies that if you want to register, CAC already has a minimum share capital for you, which you must use. If not, they will not register such companies for you. So finally, we are going to talk on our final topic, which is law of contract. When we say contract, we are just saying enforceable legal obligations agreed upon by parties. That means there must be consensus between parties that we want to be binded by these obligations we are entering. So this is where civil law comes to play a part. That the civil law we talked about earlier. So parties are saying they are conferring obligations on themselves. So if any of the party is in breach, then you can sue that person to court to get your remedy. So we are going to discuss that too subsequently. So let's look at what are the basic elements or features of a valid contract. The basic features of a valid contract is offer, acceptance, consideration. When we are talking about offer, is let me use we are going to look at offer in different lights. When I say offer, I'm talking about one, a party approaching another person and saying, I want to sell something to you. That's offer. Offer can be, let's say Mr. Johnson approaches Mr. John and says he has a Mercedes that he wants to sell to Mr. John. That's an offer. An offer too can be in such a way that you stand on the road, you are waiting for a taxi. You standing on the road, it is not an offer. The taxi stopping is making an offer to you. Then you entering is acceptance. So offer too can be when you go to supermarkets, you pick that product you want, you take it to the cashier and you give him. That is you making an offer. Is for the cashier to now accept your offer. you make payment. So for every offer, there must be an acceptance. Mr. Johnson approaching Mr. John and said he wants to sell his car. Mr. John must accept that he wants to buy the car for there to be a contract. It doesn't just stop there. There must be consideration. That means a thing of value must exchange hand. That is money. So once these basic elements are there, voila, you have a contract. There is a contract because it must not be in writing that parties no. That's why our everyday dealings is a contract. We're entering a contract because there is always offer, acceptance, consideration. So these are the basic elements, the three basic elements of contract. Then we have form, forms of contract. It can be in writing, it can be oral, it can be by conduct. Writing, as we know, when parties agree to write down the terms of the contract, sign and execute it. And orally, when they just agree orally. For example, you and a taxi driver, you can agree orally, you are entering into an oral contract. Then you have conduct too. By conduct, parties can enter into a contract. For instance, some if you want to board a taxi, sometimes you don't even tell the taxi where you're going to stop. You just enter by by virtue of where he carried you and where to his last bus stop. You already know this is the amount you pay. So as a result, you've already known that okay, once he gets to this, I'm going to you just enter without saying his reward. When he gets there, you pay him. So these are some contracts are by conduct. Then we have capacity. When we say capacity, if you want to enter into a contract, the person must have that capacity to enter into that contract. You cannot enter a contract with a minor person who is underage. You can't enter a contract with him. But there is an exception to that because there is a case that has been decided by the Supreme Court way back that when the contract involves things of necessity, things that are of necessity to that minor, he is bound by that contract. Then you cannot enter a contract with a lunatic, a person who is mentally challenged, except at his lucid period. Because some mentally challenged people, there are certain times they will be mentally okay. That we refer to that period as lucid period. So if you enter the contract with that mentally challenged person during his lucid period, that contract will be said to be binding. So he has the capacity to enter into contract. So these are these are things you need to consider when you are entering a contract. Why we are discussing this law of contract is that because once you register your business, you register your company, you are running your business, your everyday dealing is contract. So it's just for you to have an idea of, because some people say, but we did not sit down and write so any agreement now. So why are you saying we have a contract? No, by conduct, by orally, there's a contract as long as these basic elements are there. Legality, the contract must be legal, which is very important. You cannot go to court and say you want to enforce an illegal contract. The contract must be legal. It's just like a prostitute going to court to say she wants to enforce, she wants to sue a client for not paying her. That in up initio, that contract she entered with that person is illegal, so it's not enforceable. So any contract you are entering, it must be a legal contract for it to be enforceable. If it is not legal, it's not enforceable. Then intention to create legal obligation. There must be intention to create legal obligation. Parties must show that intention that they want to be bound by the contract. So once you have this element, you have a contract. Then we'll look at privity of contract. When we're talking of privity of contract, we're just simply saying that only parties to a contract can sue. Mr. Johnson, for instance, Mr. Johnson and Mr. John entered into a contract for the sale of a car, and the car sold to Mr. John by Mr. Johnson is faulty because Mr. Johnson made some misrepresentation regarding the car, false facts to Mr. John regarding the car. So in this case, Mr. John's wife cannot sue on behalf of Mr. John because she wasn't a party to the contract. The contract was between Mr. Johnson and Mr. John. So as a result, there's privity of contract between Mr. Johnson and Mr. John. Mr. Johnson, so the wife cannot sue. However, there are exceptions because that's just the general rule. There are certain places the law will say no, 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 no. In this case, even though the contract is between Mr. John and Mr. Johnson, a third party can sue, the wife can sue. An example, let me give you an example of such using typical example. Let me use an estate for instance. Let's say Mr. Johnson bought crackers in one of these estates in Abuja, and he develops the estate. You know, all these estates, they have a covenant, restrictive covenants, saying you should not do this, you should not do that. So by that, he sold the house. Mr. Johnson eventually sold the house to Mr. John. So Mr. John decided to expand his world to certain place. By the covenant in the estate, you can't do that. So in that case, even though the contract is between Mr. Johnson and Mr. John, the estate management can sue Mr. John, even though the contract was between Mr. Johnson and Mr. John. So this is an exception, one of the exceptions to privity of contract. And when we talk of terms of contract, we are talking about we're talking about the terms. That is what parties agree. I agree to sell my car. It's selling the car is functioning well. These are just terms. Yes. So these terms can be expressed or can be implied. These terms can be expressed or implied. Expressed in the sense that they are written clearly for parties to see. Implied is that as a result of that, there is something that is implied in that, in carrying out that express term. Let's say you want to carry out, let's say Mr. John is selling a car to Mr. Johnson. So he said there is even though it's not expressly stated in the contract that the engine of the car should be functioning properly. There is an implied time that at the time he's selling that car to Mr. Johnson, the engine is functioning. So implied terms are not always expressly stated. They are implied as a result of carrying out an express term. So let's what the next subtopic we'll look at is vitiating element in a contract. What can make a contract to be invalid? Well, we have duress. Duress is when you force somebody to enter into a contract. That means you use direct threat on that person. That it mustn't be direct threat on the person. It could be somebody who is close to the person. You are using threat on the person, and you're telling the person if he doesn't enter the contract with you, you are going to deal with so person. So that kind of contract is invalid because you first there is no consensus, consensus to enter into the contract because there was no legal intention by parties to be bound by the contract because parties was forced to enter into such contract. Then you have undue influence. Undue influence in the sense that uh, uh, you have an influence over the person and you use that influence to make the person to enter the contract. Undue influence can exist where there are special relationship. Let's say you have a special relationship with the person, or you have a professional relationship with the person, and then you know that the contract is to your advantage and you advise that person to enter into such contract. That contract will be invalid because you use that advantage you have over that person to make him to enter into that contract. Then we have misrepresentation. When you misrepresent facts before or at the time of entering the contract about the subject matter of the contract, in that instance, in that scenario, such is such in such a case, that contract will be vitiated because you misrepresent. It's based on the fact you misrepresented to that person that he entered into that contract. So in that case, that contract will be invalid. Then we have what we call mistake. Mistake in the sense, mistake in law is not mistake in the literal uh, meaning of mistake, as you know. Mistake can be the subject matter of the contract at the time you are negotiating, or you even made payment you are not aware that the subject matter of the contract is no longer in existence. Let's say, for instance, Mr. John and Mr. Johnson are discussing about buying a filling station, and the owner of the filling station is Mr. Johnson. Unknown to them that at the point they were making payments, they were busy discussing, the filling station has been destroyed by a storm. So in such a case, such contract is invalid because the subject matter of the contract is no longer in existence. Mistake can also be in, let's say Mr. Johnson wants to sell his Mercedes and BMW, for Mercedes for 50,000, BMW for 30,000. Then he approaches Mr. John. Mr. John thought Mr. Johnson is selling the BMW and the Mercedes for 50,000, and he makes payment 50,000, thinking it's the two car. So in such a case, there is a mistake. So such contract is invalid. Then the next subtopic we'll look at is discharge of contract. How can the contract be discharged? When parties enter into contract, how can such contracts be discharged? Such contracts can be discharged by performance. That is, when each party has performed his own obligation of the contract, then there can be said to be discharged. Such contract is discharged. Frustration, frustration is occurs when the subject matter of the contract is no longer in existence. Just like the example of mistake I used, the filling station they were busy negotiating for is no longer in existence because it has been destroyed by storm. In such a case, in such a case, uh, in such a case, then the contract has been discharged by frustration. Then we have fundamental breach. This goes to the root of the contract. Let's say the person is to supply an iPhone for you, then he supplies HTC. There is, based on your agreement, is iPhone, not HTC phone. So based on that, the contract is totally flawed. It is not there is a breach. So as a result, that contract was said to be discharged because the other party has been in breach of the contract. Then parties can decide mutually to end a contract without even performing it, without either of the parties being at fault. They'll just say, okay, uh, we don't want to perform the contract. Let it just end. So these are ways by which we can discharge contract. And the final subtopic we are going to look at is remedies for breach of contract. When there is a breach of contract, what are the remedies available to parties? One of the remedies available to parties is damages. Get damages. That means damages in the sense that you are entitled to monetary compensation. Monetary compensation, that means the other party is paying you money. You are approaching the court that the other party should pay you for as a result of that other party being in breach of the contract. You suffered some damages, and damages can be general, it can be specific. So when is general, when it's general, the amount you request. When it's specific, you list out what you suffered, then you add everything and you ask the court, this is what you want. Specific performance on the other hand is just telling the court that you have performed your own part of the contract. You want the other party to perform his own part of the contract. That means you entered a contract with another person, maybe for the supply of 50 bags of rice, and you supplied the 50 bags of rice at a particular location he ordered, and he's refusing to pay. You can approach the court that you want him to perform that contract. But because in before this specific performance is an equitable remedy, so hardly does court grant this performance and this remedy where damages will be enough. Mostly where the court will grant this remedy is where it involves land, where your contract with the person it involves property or land. That is where court will normally grant specific performance, compelling the other party to either transfer the title possession to you after you've made part payment for the property. Then we have what we call ratification. Ratification in the sense that the court will just alter the terms of the contract. The court will just alter if you supplied if the person is meant to supply 80 bags, then he supplied 50 bags of rice for you. The court will say, okay, since he has supplied you 50 bags of rice, why don't you just pay him for the 50 bags of rice and uh, forfeit the other bags? You can go get them from somebody. So the court can ratify terms of contract depending on the circumstances surrounding that particular contract and the case. Then we have injunction. Injunction is just simply stopping a party from carrying out an act. They are saying, I don't want that party. You can go, you can ask the court for injunction that this person should stop disturbing me, or injunction, anything, your property. That's why you see in land matters, courts, lawyers asking court for perpetual injunction. That is stopping the other party from carrying out anything. Then we have what we call the quantum merit. That is for reasonable value of service. For the reasonable value of service you offer, and where the contract is terminated and it's not your fault that the contract was terminated, and you've offered a reasonable service to that person, you are entitled to payment for that services you offered. Let's say it's construction and you were constructing a building, then suddenly the owner of the building says he doesn't want you anymore, he wants you to pack up, and you know it's not fault of yours. You can go to court, ask for a consummary that you should be paid for the services you've offered for him so far. Then finally we have rescission. That is called receding the contract totally. Court ending the contract, saying there is no more contract between the parties. So this is we've come to the end of today's class. I hope what I listed earlier as the objectives of this course, I guess participants, whenever they are asked about any of the things I listed as the objectives, as what we want participants to learn, they will be able to give. I don't expect you to give details, but at least you have an idea of those things I listed as objectives. So now it's time for questions and comments, observation, and even contribution. If you want to contribute on something you have knowledge of, you unmute your mic and ask your questions, you contribute, you raise your observation. The time is now. You unmute your mic and ask your question. If you have any question, unmute your mic, or you have any observation or comment to make, or you want to clarify something, you can unmute your mic and ask your question.
Hello, good afternoon. I can't hear. Hello. Hello.
Afternoon, sir. Afternoon, sir.
Yes, afternoon. I think the lesson is quite lengthy. If there was a break, one would have really have time to really ask questions. But I think it's quite educative, especially those requirements for those regulatory bodies.
Yeah, yes,
I think it's quite very informative. I just want to comment that you have done very well, sir. Thank you, sir.
Thank you very much, sir. Okay, thank you, sir.
Right.
So, thank you very much, sir, for that. Thank you, sir. So, in the absence of any question, contribution, or comment, you prepare for your post quiz. Okay, somebody has a question, Mr. Sylvester. I can hear you.
Good afternoon.
Afternoon, sir.
Thank you for a detailed lecture. Just like what my colleague actually said, you were quite lengthy, and in between the lecture, one missed one or two questions to be asked. Well, I just want to suggest how can we get the documented
Oh, they
version
will,
of.
they will, they will give you on the platform. They will
Okay.
post it
Then
on the platform.
secondly, away from the lecture, for instance, when the loan is given, and I think they have a 7 years to remit, right?
Yeah, yes, sir.
Yes. If maybe there is maybe within the pace of that 7 years, somebody actually defaulted. So what are the penalties?
CBN will know what penalty they will take at that time. But I don't think, because I believe they've already have a mechanism of how to recover their money.
Their
But from
money. Okay.
the way the loan is structured, I think people obtaining the loan should be able to repay back, since you enjoy maximum of 18 months on principal, moratorium of 18 months on principal, and 6 months on interest. I think if your business is good, you should be able to repay. I believe federal government has a way of getting back
Recover
their money, and moreover, the law has made provision for how they will get back their money
their
in the
money.
course
Okay.
and the rest. Thank you very much.
Okay. Sorry again. I away from your lecture. I think the man that gave Mr. Awocho that gave lecture
Hmm.
yesterday, he made a point which I actually was trying to ask question, but the network was actually poorly, or maybe I did and he did not actually. He
Okay.
said that let's say 10%, 70% of the loan that will be given, that the bank will actually get the equipment for the person securing the loan, and then 30% for the I think working capital. So
Okay.
my question is, I wanted to ask him, as in, how feasible is that the money for the incurring of the the procurement of the machineries or things that will be needed will be 70% of the 10% of the whole money. I don't know. I don't know if you can throw more light on this, please.
Let me the best advice I'll give you. You're on the platform, right?
Yes, I am.
And I think you direct the question to the platform, because all the people that have, that have taken classes and will take you are on the platform. So when he sees that question, he will be able to address it.
All right. Thank you.
Post it on
Thank
the
you.
platform and you get it. You post
So how
it.
do we get the materials of what the lecture you just given?
They'll post it too on the platform.
Okay.
Mm.
All right. Thank you. I appreciate.
Thank you very much. So
Yeah.
we've come to the end of today's class. So you just wait for your post quiz. Then after then you are done. Thank you very much.
All right. You're welcome. Oh.
you. I'm just here to inform you that tomorrow there will be 2 modules. So prepare for 2 modules, not just one like today's class. Thank you very much. We've come to the end of this class. Thank you very much for your patience and for your listening ears. See you guys tomorrow. Thank you very much.
Yeah.